Going through a divorce is a significant life event. Understanding the process can help alleviate some of the stress and uncertainty. If you're facing a divorce in California, this video will walk you through the essential steps involved in every divorce. While every case is unique, the guide will provide a general overview to the process. What's up, everyone? I'm Mark Reel Jr., the Father's Rights Attorney. And before we dive in, if you're facing divorce or other family court issues, give us a call at the number in the description or click the link to schedule a free, no obligation consultation with my team. Now moving on to the steps of divorce. Step 1. Filing a petition for dissolution. The divorce process officially begins when one spouse, the petitioner, files a petition for dissolution of marriage with the Superior Court in the county they reside. California is a no-fault divorce state, meaning you don't need to prove any wrongdoing by either spouse to get divorced. Common reason cited is irreconcilable differences. Along with the petition, the petitioner will also file other initial documents such as a summons and potentially other forms depending on the specifics of their situation. Step 2. Serving the respondent. Once the petition and summons are filed, the respondent, the other spouse, must be formally served with these documents. This means they must be personally handed copies of the paperwork by someone over the age of 18 who is not involved in the case. Proof of service confirming the respondent was served must then be filed with the court. Proper service is crucial as it officially notifies the respondent of the divorce proceedings and establishes the court's jurisdiction over them. Step 3. The response. After being served, the respondent typically has 30 days to file a response with the court. In their response, the respondent can agree with the petitioner's requests, disagree with certain aspects, or make their own requests regarding issues like property division, child custody, and support. If the respondent fails to file a response within the 30-day time frame, the petitioner can potentially proceed with a default divorce, where the court may grant the petitioner's request without further input from the respondent. Step 4. Temporary orders. This is an if needed step. During the divorce process, which can take from several months to several years, temporary orders can be put in place to address urgent issues. Either spouse can request temporary orders regarding things like temporary child custody and visitation, establishing a temporary parenting schedule, temporary child support and spousal support, providing financial assistance during the proceedings, or restraining orders preventing certain actions by either spouse. Next may be something like exclusive use and possession of the family home, determining who lives in the marital residence temporarily during the divorce. The court will hold a hearing to determine whether to issue these temporary orders based on the needs of the children, financial circumstances of the parties. Something to note, mandatory mediation for custody. In California, when there are disputes regarding child custody and visitation, mediation is typically mandatory before courts make orders. This applies to both temporary and permanent custody arrangements. Typically, the courts will refer the parents to a court-connected mediation service. The goal of custody mediation is to help parents reach mutually agreeable parenting plans that are in the best interest of their children. The mediator is a neutral third party, typically an employee of the court, who facilitates communication and helps explore different options. While the mediator will not make decisions for parents, they can provide guidance and help identify common ground. If parents can reach an agreement in mediation, the mediator will typically prepare a recommended parenting plan for the judge to review and approve. Only if mediation is unsuccessful will the custody issues proceed to the contested hearing and eventually trial. Step 5. Discovery. Discovery is the formal process of gathering relevant information relevant to the divorce case. Common discovery tools include preliminary and final declarations of disclosure, informally known as PDDs or PDODs. These are mandatory financial disclosures required for the courts to grant a divorce. They include disclosure of property, bank accounts, and really anything financial or property in your life. Interrogatories are written questions sent to the other party that must be answered under oath. These are typically used to gather basic information or get the opposing party to commit to certain facts. Next, you may have requests for the production of documents. This is demanding the other party provide specific documents, bank statements, tax returns, other financial documents. Another common tool is depositions. Depositions are oral examinations of the other party or a witness under oath. Discovery helps each party understand the other's financial situation, assets, debts, and perspectives on various issues. This information is crucial for negotiation and, if necessary, for trial. Step 6. Mediation or settlement negotiations. Beyond the mandatory custody mediation, California strongly encourages parties to settle all aspects of their divorce outside of court. Mediation can be used for property division, support, and other issues, or settlement negotiations can occur directly between the parties or their attorneys. Reaching a full settlement is often less expensive, less stressful, and allows the parties more control over the outcome of their divorce. If a settlement is reached, it will be written into a legally binding marital settlement agreement. Step 7. Trial. If parties cannot reach a full settlement on all of the issues, all unresolved matters will proceed to trial. Now, it should be noted, only the unresolved issues. So if you settle custody or community property, it doesn't need to go to trial. At trial, both parties present evidence and testimony to the judge, who will then make decisions on those remaining issues, including property division, child custody, and support. Going to trial can be time-consuming, expensive, and the outcome is ultimately decided by a judge, not the parties themselves. Step 8. Judgment of dissolution. Whether through full settlement agreement or the judge's ruling after trial, the final step is issuance of a judgment of the dissolution of marriage. This legally ends the marriage and outlines the terms of the divorce, including property division, child custody and visitation schedules, and spousal and child support orders. It's important to note that in California, there is a mandatory 6-month and 1-day waiting period from the date the petition was served until the marriage can legally be terminated. The judgment will specify the effective date of the dissolution. Step 9. Post-judgment matters. Even after the judgment is entered, there may be post-judgment issues that arise. This could include modifications to custody or support orders due to change in circumstance, or the enforcement of existing orders if one party is not complying. Navigating California divorce involves several key steps, and when children are involved, mediation is crucial and often mandatory part of the process to help parents prioritize their children's well-being. Remember that it is a general overview, and your specific situation may involve additional complexities or require different approaches. It is highly recommended that you seek legal advice from a qualified California family law attorney early in the process. An attorney can explain your rights and obligations and guide you through each step, including the mandatory custody mediation, and advocate for your best interest and the best interest of your children in front of the judge. Divorce can be challenging, but understanding the process, including the emphasis on what your rights and responsibilities are, can empower you to make informed decisions that move you forward with greater clarity. Thank you for watching. If you found this video helpful, please like and subscribe to the channel for more content just like this. And if you have any questions or would like to talk to someone on the Real Fathers Rights team, comment RFR below.